Hello. With all the recent activity in the news about transgender and sharing bathrooms and locker rooms, I thought we might take a moment to talk about a recent case, actually an ongoing case that deals with this subject. It's a case out of Illinois, and it's about sharing bathrooms and sharing locker rooms. And it's interesting to have an actual case to put some flesh on the bones, as it were, and see how some courts are actually dealing with this kind of litigation. This decision came down March 29th of this year, 2019. It's the Students and Parents for Privacy versus the School District of Township High School District 211. Got the case number for it here. We'll just say SPP for the plaintiffs here, and the school district or school district 211 for the defendants. The question at this point in the case is, will the case be dismissed? And for this purpose, the court assumes that the factual allegations in the complaint are true. That's important to keep in mind because, as we'll see, some of the things that are alleged in the complaint, it's not entirely clear whether they will be able to actually prove that some of these things happened. But the posture here is there's a motion to dismiss, and for that reason, there's an assumption made by the court that the things that in the complaint are actually true as regards to the actual facts in the complaint by the plaintiffs. The plaintiff's point of view, let's discuss that just briefly. The plaintiffs, students, and Parents for Privacy, SPP, is a voluntary, unincorporated association of students who are attending the high school and their parents. This is essentially the conservative Christian point of view. They are opposed to the high school sharing of locker rooms via the school LGBT policy. Basically, their point of view is a person's perception of his or her own gender does not change his or her primary or secondary characteristics or their own genetic makeup. So basically, you're born a man or a woman, a boy or girl, and that's just the way it is. You like it, you don't like it, but you can't change it. So they're opposed to any sort of policy, switching bathrooms, anything like that. The defendant is the school district, so they have come up with a policy, and as part of that policy, they seek to affirm the claimed genders of students by allowing the male students who claim female gender to use the privacy facilities, the bathroom and locker rooms designated by the female sex. Also, female students who claim the male gender to use privacy facilities designated for the male sex. So basically, they're allowing the high school students to share locker rooms. Now, in this case, what we have is female locker rooms that are being used by male students who claim female gender or transgender male to female students, however you want to discuss that. We're talking about this first case here. You could have fact situations where female students who claim male gender are going into the traditionally male locker rooms, but as the facts unfold here, we have the female locker rooms and the people with male genitalia going into those locker rooms. The plaintiffs, basically the high school girls, their view is that the policy causes students embarrassment, humiliation, anxiety, fear, stress, degradation, and loss of dignity. Essentially, the girls say that they were startled, shocked, embarrassed, and frightened by the presence of male students in the girls' restroom and also the locker room, the showers, the changing room. One girl said she was exposed to student A's penis. They don't give the student's name here, privacy reasons. After District 211 allows student A to use the girls' locker room, one parent requested that her daughter be allowed to use a private locker room, and the district refused. I think the district here was just put in a very difficult position. They just don't have locker rooms for each and every student that might want one. So, the policy is the policy, and they just are not going to accommodate any individual student. The school district, they have a so-called compelled affirmation policy. Whether you view it as a compelled affirmation or whether you think they're compelled to affirm the policy or just compelled to abide by it, the students are required to follow the policy in the locker rooms. And basically, the students are permitted to use the restroom in locker room facilities of their choice, regardless of how the student presents and whether the student shows behaviors or characteristic stereotypical of his or her claimed gender. So basically, there are no particular rules, if you will, on how the students look, how they act, how they behave. If you want to use the female locker room, you can use the female locker room. If you want to use the male locker room, you can use the male locker room. The students are compelled to go along with this. There is no opting out of this, so to speak. The district's view of this is you can leave the locker room if you don't like it. You don't have to stay in there if someone's in there and you don't like it. And this is kind of interesting here, the plaintiffs here, the parents and the high school girls basically, they claim that if you object to the policy, you are intolerant and bigoted. This is something that they claim that the high school has made these parents and high school girls, this is how they've made them feel. Now, it's not entirely clear how the high school has done this. I seriously doubt there's been an official policy statement or written material passed out saying, hey, if you don't like this policy, we think you're bigoted, but maybe there have been statements made or something like that. This is something that the court just, again, they are going to assume that this is true for the purposes of this motion to dismiss here. The court does talk a little bit about the impact on the girls. Some of the girls began wearing gym clothes underneath their school clothes to avoid getting undressed in front of the male students or the transgender students. Some of the girls used a private changing stall in the girls' locker room, after which some of the other girls began to call the girls transphobic and homophobic. They shower after swim class in open showers that are visible to other students, and they became fearful when they were naked. Again, the male students would be coming in, seeing them essentially naked. And there is a swim class, and essentially you have no choice. You can't wear your wet swim clothes underneath your clothes for the balance of the day, so you have to take a shower. You have to you have to be naked for at least a little bit. Some of the girls use the restroom infrequently, which presumably caused some risk of urinary tract infections, dehydration, constipation. Some of the girls use the restroom during class to reduce the risk of encountering a member of the opposite sex in a restroom. So as a result of this, they were actually missing class time to go to the restroom because they didn't want to do the changing and using the restroom during the PE classes and during class breaks. So in a sense, it was possible that this was having an effect on their education. One of the claims that the girls brought was Title IX. Um, Basically, it's no person shall, on the basis of sex, be denied the benefits of an education. This is for any kind of school that receives federal funding. And the court talks about any time that there is a deliberate indifference to sexual harassment that is severe, pervasive, and offensive, and deprives the victims of access to an educational opportunity. The school may be liable for that. And in fact, the cases in this area have shown that this is a fairly low standard. They cited a case that said, during my employment, I was subjected to sexual harassment. I complained to no avail. So the complaint doesn't really need to say very much, and the court ended up concluding that the plaintiffs basically stated a claim for sexual harassment. They do say that whether they can ultimately prevail on that claim is a question for another day. They're not here to decide that. They do make that clear, but they're not going to dismiss that claim at this point. The girls also claim they have a right to bodily privacy. The way they explain it, they have a fundamental constitutional right to bodily privacy that protects their partially unclothed or fully unclothed bodies. They have a right to be free from government-enforced, unconsented risk of exposure to the opposite sex when they or members of the opposite sex are partially or fully unclothed. Now, the court says that this right is not explicitly found in the Constitution, which of course is true. There is no right to be naked without somebody seeing you naked, or without seeing someone else naked that's not of your same gender. So they do say that if this right does exist, it has to be found in the Due Process Clause of the 14th Amendment. So they talk about that. The 14th Amendment provides protection against government interference with certain fundamental rights. And they do talk about, historically, there have been these 7. Even though these aren't specifically mentioned in the 14th Amendment of the Constitution: the right to marry, the right to have children, the right to basically raise your children, direct their education, the right to marital privacy, the right to use contraception. There's an interesting case, the right to bodily integrity. There was a so-called stomach pumping case where the police were putting their fingers down people's throats, taking them to emergency, having their stomachs pumped because they thought that somebody had swallowed something. The courts in those cases said, you know, this is just too much. We're not going to allow the government to start invading people quite that much. And also a big controversial right for some people, the right to abortion. You might also view 6 and 7 as medical treatment, the right to have or reject medical treatment. This is also sort of bodily integrity, is the way some courts have viewed these rights. They say that the right not to be seen unclothed by the opposite sex, or to see someone unclothed who is the opposite sex, is not on the Supreme Court's list at this point. They discuss it a little bit. Public locker rooms are not notable for privacy. Again, the girls presumably don't have any problem, at least not as much of a problem, with other females seeing them naked. So there's not an absolute right to be seen naked. They do talk about nudity as a taboo, and it is true that some people have more of a problem with the naked human body than other. than other people. Some level of adult privacy uh, is kind of recognized in the law. Um, they do talk about maybe there is some degree of privacy for urinating in front of the opposite sex. Maybe in certain law enforcement contexts, this might come up. There might be some degree of this business for adults, but they're just not willing to extend this kind of right at this point. So the court dismisses this 14th Amendment right to concerning nudity. The Illinois has a Religious Freedom Restoration Act. Basically, the idea here, the government may substantially burden a person's exercise of religion only if it's in furtherance of a compelling governmental interest, and it is the least restrictive means to do so. They did conclude that the plaintiffs have included sufficient facts to allow this claim to continue to live for another day. Again, whether they can actually prove this is another question. The free exercise of religion is a claim that the plaintiffs are pursuing here. And this is interesting. The court says, you know, this policy by the school district is facially neutral. It really has nothing to do with religion per se. The allegations in the complaint do not suggest that the policy actually targets religion. It doesn't favor religion. It doesn't harm religion. It really has nothing to do with religion in a way. This is going to be interesting for the future, how this case unfolds. The plaintiffs say that the district conveyed to students that anyone who objects to the compelled policy is a religious bigot or is religiously intolerant. So even though the policy is not necessarily a problem, the way the policy is being implemented or enforced may have some religious implications. So that is going to be interesting to see how this actually plays out, and how the school district, what they said about the policy, and you know, what the plaintiffs are going to have to prove in order to prevail on that. So basically, the outcome so far, the lawsuit continues. I will say, you know, the strengths and weaknesses of the case, as I see it, there is something about the facts, the if I had a daughter thing. You know, there is some sense in which the girls are sympathetic, you know, especially if it's causing medical problems and they can document that. You know, teenage years, those can be kind of rough. At the same time, you know, for their transgender students, that can be rough for them too. So, you know, that, you know, the facts can be kind of compelling here, maybe on both sides for truly, you know, biology problems on both sides. The weaknesses of the plaintiff's case here, it's not clear to me exactly how this is religious, unless there is some evidence about the school making some weird statements about religion. There are no clear constitutional rights about nudity in high school locker rooms. Exactly what did the school district say to convey to students that anyone who objects to this policy is bigoted or intolerant? We're going to eventually see that, I have a feeling. I don't think this case is going to go away. So we're going to have to see what the school district actually did when this policy first came out, how it was put into place. And, you know, so stay tuned to this. The case continues to live for the time being. And we're just going to have to see how this develops here. If you're in a school district and you come up with one of these policies, it looks like you're going to have a lot fewer problems if you don't make it about religion at all. Just don't talk about religion at all. Because if there is going to be a problem here, at least on the religious accounts, it's going to be much better, for the policy if you just keep religion out of it. So again, continue to watch the case. It's in the federal courts in Illinois, and let me know your thoughts about it.